I take this opportunity to welcome all the Propathon 23 attendees for attending today's panel discussion. It's our endeavor at PropertyAngel to host industry leaders and experts as we create meaningful dialogues on the most interesting issues of the day. All those who are watching us, are you feeling overwhelmed by the many complexities involved in purchasing a property? After all, real estate is one of the most expensive asset investment which you do, and it's a very, very complex process. Well, don't worry about it. We're going to take care about it. We have our experts today who are going to be breaking down the various steps which are related to property purchase. And we will talk about the documents and the documentations which are very important for a purchase of property, which includes title deed, sale agreement, power of attorney. We will have this discussion. We have a wonderful team here. They have made an extraordinary effort by their presentation. Welcome me in joining in today's two panelists, Naveen Raj and Pranati Pandit, both experienced lawyers at MMB Legal, a Bangalore-based law firm. A warm welcome to you, both of you, my friends, for joining us today for this very important discussion. And you both are lawyers, so you know the importance of legal documentation and various kind of processes which are required. Real estate is indeed a very, very complex process, right? So I will request Naveen to tell us about the importance of title document. And then after this presentation, which Naveen has prepared, we will be talking about estate planning, which presentation will be taken through by Pranati Pandit. Naveen, can we start your presentation? And we are all very excited and looking forward. I have been told that you have done some mind-blowing presentation.
I'm only humbled at that. And thank you very much.
So, a very serious note. I mean, 30 years of experience in real estate. Even now, I still don't know, right? So it is, we all know that property purchase is indeed a very complex, kind of a process.
I agree. We all agree to it. Yes, very much. Yes.
There you go. Amazing. So we're going to be talking about property acquisition, importance of title document.
Correct. Yes.
The floor is all yours, my friend Naveen. Go ahead.
Thank you very much, Sangeet. Welcome to everybody in taking you through our humble effort to acquaint you with the process and the watch outs that you need to maintain while acquiring a property. In India, more and more people are acquiring property than ever before. And again, more and more people are acquiring more than one property. The speed of acquisition of property has been very fast. It's growing, it's accelerating. People are now buying properties at intervals of 5 years, 3 years, 8 years, etc. Whereas just a generation ago, properties were bought once in a lifetime. Okay. So it's become very imperative that people know what they are buying and not land up in a situation like this cartoon explains as to, in a way, where one person has bought a property and is not clear on what he's bought, how many acres, he doesn't even know what an acre is. Of course, this is an exaggerated cartoon, but it certainly reflects what most of us go through. We end up buying a property on the basis of our physical check. We go see an apartment, we see a land, we like it, and then on the promises or assurances, sometimes just because a friend has bought, we go ahead and make the purchase. Okay, but property, as Sangeet just mentioned, is acquired is a very high value. In most cases, that's the highest value in assets owned by an individual. However, because of our current practices, we often miss the importance of having a good title to the property. What does title mean? Title means the ownership of one person to a property. Okay, and ownership in India, as elsewhere in the world, is only proven by documents. So title documents are the most important thing, right? Okay. How does one acquire title to a property? That is, how does one acquire ownership to a property? Firstly, by transaction between two parties, which is the sellers and purchaser. Sellers could be multiple parties, buyers could be multiple parties, but there are two sets of parties. They are private people. They're buying, one is selling, the other is buying. Second method of acquiring a property is by receiving a property through grants or some kind of a program made by the government. For example, sports personalities, celebrities, high achievers in science and arts, etc., are given property in recognition of their achievements or contribution to the society. Likewise, the socio-economically backward classes are also given property so that they become sustainable and start coming into the mainstream of the developing country. These are properties acquired in full ownership, but sometimes they come with restrictions on transferability. That should be borne in mind. The third method of acquiring a property is by a gift or something, where the donor who's making the gift executes documents solo, all by himself. There are no two parties required for making a gift deed, for example. So the donor gives the gift to the donee, and it's a one-sided document. The donee becomes a beneficiary and a full owner of the property. The fourth one, which is executed by third interested parties. What does that mean? When a property is bought, we realize, especially those properties which have got transferred from generation to generation in a family, there and in India, thanks to the size of the family and the personal laws of the people, the inheritance rules now make everybody, including daughters, and to the extent that the children of deceased daughters, that is the grandchildren, also become inheritors, heirs of the property. So while acquiring a property, while the main buyers would be executing the sale deed, it also needs to be supported by documents or by which the other remotely interested parties also execute necessary transfer deeds. This could also happen in the case of a property which is bound to allow some third person to use the property to some extent. This happens mostly in the case of land, where the land owner is obliged to give right of passage to a third party who could be a neighboring owner. Okay, so this happens, I'm very sure, in the rural side with where agricultural property are large, but there are no roads. And traditionally, because the neighboring landlord also passes through one common way, which is actually the property of one owner, the right continues to be available. So where required, such third parties who are interested in the property, hold special rights in the property, may also be required to be roped in getting a proper perfected title. Coming to in India, there is a, for lack of better word, confusion in the documents which give title to a property ownership to a owner of a property, and other documents which are often purported to be ownership documents. So let us understand the difference between the two. First, those documents, let's take those documents which depict ownership, which clearly prove the ownership of one person over a property. Sale deed. Sale deed is a definite document. If executed properly and duly registered, it is a conclusive document to prove one's ownership of a property. The will of a person becomes an effective document showing ownership of the beneficiaries of the property bequest after the demise of the executor. So it's a very definite document. Likewise, a gift deed. The executor is a single person who is executing all by himself, does it without the consent of the beneficiary, but still the beneficiary gets title to the property. It's a definite document again. Partition deed. Partition deeds are made when the owner of a property passes away without directions by will or anything as to how it should be transferred to the next generation. And the heirs come to a consensus and make a deed depicting which heir gets what share of the property, etc., with all details. This is a very definite ownership giving document. Exchange deed. Exchange deed is not very popularly used, but it's certainly a title giving document. In an exchange deed, there are two sets of owners, each owning a property. Now, under this deed, the property of one side moves to the other side and vice versa. So they get the properties exchanged. That is called an exchange deed. It's a valid deed and it is the ownership giving deed. The sixth method of document which gives a title or ownership to a person over a property is the government grant deeds. I've already explained on the government grant deeds. These documents are issued by government or governmental bodies like development authorities, urban development authorities, etc. All these are valid title deeds. Moving to those documents which are not title documents, they're actually documents which sometimes or in most cases enable transfer of title, which is they have to be supported. These only are methods to acquire a property which give some rights, but they're not conclusive on transfer of property. So these have to be followed up with a proper sale deed, gift deed, etc., etc. Okay. For example, an agreement to sell is the holder. It makes the holder avail a right to buy the property, but it does not make him the owner by just this document alone. So one should be very clear that when one engages to buy a property and there is an agreement to sell only with the purported seller, you should be clear that he doesn't have the right to sell. He is not the owner. That's one caution that you must bear in mind. Often tax records like khata certificates, tax paid receipts are also supported or given as supportings to property transactions. They are only supporting documents which corroborate the ownership, but they're not final or conclusive. Power of attorney. Power of attorney is a very widely used, it used to be even more widely used across India for property transfers, including for effecting sales. Now the Supreme Court has clarified adequately on it. A power of attorney is an arrangement whereby one person appoints another to act on his behalf in relation to a property. So the person who is a holder of a power of attorney only acts on behalf of the owner. He himself does not become the owner. This should be very, very clearly borne in mind. So when somebody tries to sell a property on the basis of holding a power of attorney, one needs to check the validity of the power of attorney. One must check the powers given under the power of attorney and thereafter execute a sale deed. This is additionally, power of attorneys for the purpose of sale will often be required to be registered depending on the state laws across India. Allotment letter. These are letters issued by urban development bodies or society development promoters, etc. These people, this is a communication to an applicant saying that he has been selected for selling a property to him, the property to which he had applied for. This only gives him a communication and nothing else. The applicant who receives an allotment letter has to certainly engage with the promoter or the authority and get a sale deed executed in his favor. Only then does he become a owner. Prior to that, he is not an owner. The allotment letter is mostly a communication and nothing more than that. Utility bills are these electricity connection bills, the water connection bills, utility such as gases, telephone, etc. These are often used as address proof and identity proofs in our general discourse of life. However, as far as property title is concerned, these are only supporting material. They don't form the main core ownership. They don't give any ownership. Okay. Um, Encumbrance certificate. Encumbrance certificate is a reflection, is a mirror view of the records maintained by a sub-registrar stroke registrar of a place. All property transfer, ownership transfer documents have to be compulsorily registered. And when a registration is made, the records are open for public viewing. So anybody can apply for an encumbrance certificate for a given property for a selected period, and the sub-registrar's office will give him a certificate depicting all transactions made on the property within the period. This shows the flow of events with respect to the property, but by itself doesn't assure title of the current seller. Often, we notice that, as I just in the beginning mentioned, we end up buying properties without exercising due diligence and due importance on the title verification, and end up realizing defects, flaws, or serious concerns of having been totally cheated, that they've been sold the wrong property or the seller was a fraud or anything like that. And the reaction is, oh my God, I wish I had got the title verified and not followed what my friends and referrals or the lure of a good deal, a cheap deal, etc. Benefits of a good title. When a when the title of a property is good, which means that it is lawful, it has no confusion, etc., and it establishes the ownership of the owner very clearly, it gives some benefits. Some of them are, it provides complete and undisputed ownership. So all questions on possible disputes about the ownership have already been resolved while acquiring the property itself. It establishes clear obligations, if any, in case the property is supposed to be allowed to be used to some extent or in some portion by a third party, that is enumerated and the buyer clearly knows what he's buying. It identifies the nature of the property and its permissible uses. This is another important thing. In India, we have agricultural land which has to be used only for agricultural activities, residential properties which have to be used only for residential usage, commercial property which must be used for commercial and not for setting up industries, and industrial property. One has to know as to what he is buying the property for and whether the property is allowed to be used for that. That's one important check. A good title, the advantage of holding a good title is that litigations are avoided, including interpretation issues. If there's any litigation or any dispute or any question, the document should be able to be used to interpret, showing the correct rights or ownership of the property. Then it also helps in availing quicker loans, be it private loans or loans for acquiring the property. A property, real estate property, often is used to be mortgaged to avail loans for the time being, okay? Or often the buyers I think buying property on loans is the main driving engine in the industry today. Many people avail loans. In order to avail loans, the seller must have made sure that the title of the property is very good. And a current owner of a property with good title is that much more comfortable in transferring the property to another, be it for sale, be it for gift, or for any matter. Yes. Process of verification of title. While title is so important, how do we make sure that, or what happens in verifying a title? To start with, the parent title, which is the papers which give ownership to the current owner or the previous owner, have to be checked. Then government records should be checked, which is the encumbrance certificate, to go and verify if there are any transactions which have happened on the property. The documents executed or in the which give the title to the current owners need to be checked as to whether they were properly executed. Because if there is any dispute and there is found to be a shortage in stamp duty paid, etc., then the courts can penalize the litigants. The person who wants to prove his ownership on the basis of the document that he holds will have to pay the deficit and the necessary penalties in case of a shortage in stamp duty being paid. So whether the right stamp duty was paid and whether the registration was duly and properly done as per applicable laws needs to be checked. Then third-party documents. When you find that the property transfer required approvals of third parties, such approvals must have been obtained. Usage of the property must be checked to find whether the purpose for which we want to acquire the property is being met. Utilities have to be, utility connections need to be checked as to whether they are in the current owner's name. Otherwise, if it is not in such a owner's name, transfer of the connection might be difficult, and the new owner might be forced to take new connections, surrendering the old ones. Other important thing is, while the title documents have passed this journey, the owner should also make sure that the property itself is measured and verified as depicted in the title document, which is a physical survey. That could be a simple survey by using calibrated tapes and so on, or through a professional surveyor. And no matter what verifications happen thus far, one must physically check the physical original documents. Normally what happens is when in the process of a sale negotiation or a sale finalization, the landlords would be giving the originals to anybody's custody. The owners retain it with themselves, but give photocopies for the verification to be done. As one very critical step, once having reached a matured stage of verification, the prospective buyer must get the originals verified by an expert. The original verification will involve touch and feel, understanding what is written, comparing it with the photocopies given. Having done these, one can fairly feel that they have done a decent, dependable title verification. Well, this process, this 8-step process looks 8 in number. It can branch out into many more tributary activities. That is to be borne in mind, and one must also remember that this could be a little time consuming sometimes. One has to bear the necessary patience to go through this, and trust me, it would be beneficial to everybody who goes through this process. After a title verification is made, the lawyer is supposed to give a title verification report or a title scrutiny report, as it is called differently in different parts. And such a report must contain property description, assumptions made by the lawyer, limitations of the verification, given that a lot of properties come with a huge heritage, and that some of the documents cannot be verified fully. There could be some limitations which the lawyer identifies and mentions, keeps the prospective buyers informed, also discuss the pros and cons and the risks and the roundabouts to meet it. All those are captured in the limitations. Tracing of title. Tracing of title helps in understanding the transition of the ownership of the property over the last few owners. It could be that somebody has owned the property for many, many years, and therefore there are only 2 sets of people through whom the property's ownership has passed, or there could be multiple. Whatever it is, for the given period for which the verification is made, all owners who have come in ownership of the property needs to be traced and mentioned. Rectifications covers what rectification is required with respect to the title of the papers. There could be errors in the documents. There could be shortcomings in the process of execution, all those rectifications must be availed and made prior to acquiring the property. Confirmation of title. The title verification report has to mention finally whether the current seller is the rightful owner and whether he has the right to transfer the property. After that, it has to provide a list of documents reviewed by the lawyer. It should ideally also mention the documents that were required but not received. And lastly, mention the list of abbreviations and keywords used in the title scrutiny report. To kind of bring a recapitulation, a good title document identifies and describes the property clearly, is signed by all parties who hold a share, is properly witnessed. When we say it is properly witnessed, at least two witnesses must sign the document being executed. It has to be countersigned by the interested parties. It should be written in clear and simple language so that interpretations don't become a messy affair later. Establishes ownership shares of each owner. In case of joint purchase, it is good to know and decide as to which owner owns what share of the property. Ideally, if they can also demarcate which portion of the property, that would be very good. The title document should be properly stamped according to applicable laws. It should be compulsorily registered as required by applicable laws. In India, any immovable property, which is land property, building property, etc., needs to be registered if it is of value more than 100 rupees. And it is needless to say that in India, gone are the days when somebody could buy a property of value less than 100 rupees. So it's a given thing that if one is acquiring a immovable property, the document recording the transaction needs to be registered compulsorily. And the property, in case is being granted by or is being allotted by a authority, board, development, promoter, etc., one should make sure that the document is executed by a competent authority. It should not be such that there are gaps in it. The right person, right authority, right board or promoter has to execute the document. To summarize the whole picture of what one should do while acquiring a property, one should focus upon selecting property with clear title. We often get overwhelmed or awed with the physical aspects of a property. We like the land, we like the flat, etc. And in the excitement could land up in buying a property which is very good to look and feel, but is filled with defects in its title. Between two properties of second likability but with clear title and a first likability with defects in title, please prefer the one with clear title, because clear title gives you peace of mind and certainty of what you wear or what you own. On the other hand, no matter how good the property is physically, titles can mess up ownership. It can snatch away the property altogether. It can spoil peace of mind. And in order to make sure that you bought a property, a good property with a good title, you should make sure that you've undertaken a proper title verification. We have delved enough on proper title verification. So we move to the next step, which is ensuring that commercials and finance aspects are very clear. This is an often found situation where people start the process of acquiring property by paying a small advance money or engaging in title verification, even before the commercials and the finances are completely agreed upon. And sometimes they land up with a difference in understanding to the tune of few lakhs, few millions, and the deal after a long exercise of efforts to buy fails. What are commercials? Commercials are details of when the money will be paid, in what breakups, etc. Finances are how do you get the money, what is the purchase value, all those things must be clearly identified. Drafting a good transfer deed. As already explained, a good transfer deed must bear the qualities of clarity. It should depict the property well, identify all the parties required to execute the transfer deed in brief. Otherwise, the same has already been dealt previously. After the draft is agreed between the parties, the next step is to have it executed, stamped, and registered correctly. So execution, even at the time of execution, one has to be make sure that the right draft is executed, the right stamp duty is paid, and the registration is done at the right sub-registrar's office, having paid the right fees. Here, I think we've reached a junction where one recognizes that property purchase is one line of story, and buying a property with a proper title, ensuring that we become certain owners of the property that we purchase, is another line of story. And if you want to belong to the latter one, where you bought a property with certainty on the title, etc., and given the complications and domain expertise required, you certainly will require some legal support, and ensure that you have taken adequate legal support to secure and own a good title, good property. Thank you.
Very, thanks, Naveen. I honestly, with such a long experience, I didn't realize the complexity which is there. This was a very nice presentation. It's really amazing to know. What I really liked about this presentation is when most of the buyers we make this mistake, right? When we just pick, do or take token amount without actually understanding where the title is, where the property is. And I think one of the most important aspect which today is a big learning for me, which is important for all our buyers and investors who are not that experienced, who are especially buying the property for the first time, that allotment letter is just one communication. It's not a document which is really going to be taking you, the court of law in case there is any kind of a dispute or something. Am I right, Naveen?
Yes, very much, Sangeet. Very much.
Yeah.
Yeah.
So now, and I have no, at the cost of saying this, and I will want all of our friends who are watching us, attendees, especially again, as I said, very concerned for the first-time buyers. We have a lot of, Naveen, I'm sure you'll agree, we have a lot of young buyers now coming in, right? Especially after the pandemic, property purchase for security is important. You come from a city of Bengaluru where we have a startup culture. So we are more and more people are buying property. And you started off the presentation with very, very, with a cartoon which said, you have properties, but we don't know what an acre is. So now we will, thanks a lot for this elaborate presentation. And we now will be asking Pranati to show and give us a rundown and take us through the presentation which she has prepared for all of us. And we look forward for your presentation. Now we have Pranati, who is going to take us and tell us about the estate planning, which is the the other part of the entire real estate investment and the property process. We have, as Naveen said, and in all our with our other discussions we've had, that there is a new trend where now the investors and the buyers are buying more than one property. It's not just one property. We have this, and Indians are very, we love buying properties, and wherever we are, we are one of the largest consumers of real estate, either for self-consumption or even for investments. So, Pranati, we look forward now to your presentation and to take us through the estate plan. And we will be talking about the importance of creating a will. And I think that is one real gap and one mistake where, we don't create the will. And after the death of the owner of the property, unfortunately, there are a lot of issues which are created. And it's for the family and for for the lawyer then, to resolve that issue right now. So that is why this session, my friends who are watching us and who have joined us today, is an important session. And as Naveen has made a presentation, we now look forward for Pranati's presentation, which she's going to take us through the importance of creating a will. Over to you, Pranati. Floor is all yours.
Thanks for the introduction, Sangeet. And as you said, it is an extremely important exercise for one to sit, take stock, and create a will. Estate planning is essentially the process by which a person takes stock of all their wealth and then decides how to distribute it to beneficiaries after their death. So this is something that's not going to happen. Just to really emphasize the importance of taking stock of your wealth and creating a will and deciding what's going to happen to your wealth after your death, because you can't take it and go with you. Before we jump into wills, let's talk about some common misconceptions that we have around them. One is that wills automatically cover all assets. This is absolutely not true. A will only covers those assets that you mention in it. So it's a very important thing to remember that when you are getting a will drafted, that you're very, very upfront, clear about exactly what you own. Be it intellectual property to real estate, you must be very clear on everything that is there. Wills are for older people. This is also not true. If the recent COVID pandemic has taught us anything, it's that, don't put off until tomorrow what you can do today, including your estate planning and putting things in place for your beneficiaries. Wills are permanent and can't be changed. This is not true. If I created a will today and if I decided to change that tomorrow, I can create a codicil to that will, which amends it a little bit. I can create an entirely new will. A will is only necessary for people with children. Only wealthy people need a will. This is not true. Anyone with any assets, any interests in anything whatsoever should create a will. My successors are mature. This is categorically most of the time not the case. No matter how mature successors are, what happens sometimes is that everybody can't come to an agreement on something. It's not that easy, especially with bigger families. It's just not something that you should be banking on. Let's now get into what a will is. A will is quite simply an instrument in writing executed by a mentally sound person called the testator. The testator has to be above the age of 18. It has to specify the distribution of the testator's estate amongst beneficiaries, who are the people receiving. They could be your heirs, they could be anyone else really that you've decided to bequeath your estate on. A will is carried out by an executor who is there to respect the wishes of the testator and carry out the instructions set out in the will. And the will should be signed in the presence of two witnesses. So as Naveen had pointed out in real estate documents as well, witnessing is something that's an integral aspect that comes in for documentation to make sure that the person signing that document is not being coerced, there's no undue influence, etc. I've given you a lot of big words, so let's break those down a little bit. Testator is the person writing the will. Estate is the corpus or the whole of the testator's wealth and assets. Beneficiaries are the recipients of the testator's estate or parts of that estate. Executor, again, is the person responsible for carrying out or executing the testator's wishes in the will. And witnesses should be independent adult witnesses to attest to the fact that this is, in fact, the testator's will that he voluntarily signed and without any undue influence. The benefits of a will are many. I've condensed it into the few points that you see now. It structures the transition of wealth from testator to beneficiaries. I cannot emphasize how important that structure part is, because it's essentially a roadmap, a guide to tell you exactly what the testator's wishes are. A good will leaves no room for interpretation. It ensures that your lifetime efforts are not wasted. So in the event that you die without a will, let's say, you don't have a will, in that situation, what happens is applicable law kicks in. When that happens, your assets are distributed according to the law that might not be what you want or how you desire it to be. Also, in an India context, different religions are ruled by different inheritance laws. So depending on what religion you belong to, that could have an impact on who gets what share of your wealth. One more very important point, it serves as evidence before banks, other institutions, regulatory authorities for transfer of wealth. So this, as Naveen again had pointed out, that a will is a title document. So if you take a will to a bank or any other, let's say, authority and say, okay, this is part of the evidence of my ownership, that is something that will be taken seriously. A will mitigates family disputes, conflicts, makes things just a lot clearer for beneficiaries and heirs. It safeguards the rights of minor children. So if you have assets that should be benefiting them, you can state the way in which these assets will be dealt with. You can appoint someone to manage those assets for your minor children until they attain majority. It reduces wastage of time and money of beneficiaries for sure, because inheritance after a will is quite a complicated process. It's if there is no will, then it becomes quite, it's quite an effort to be able to then transition that wealth and distribute it to beneficiaries. And at the end, it provides peace of mind knowing one's affairs are in order. You're leaving, but you're not leaving an absolute mess behind you. So a good will should be, even in light or even in the face of an extremely complicated maze of an estate, your instructions should be perfect. A good will complies with applicable laws. It accounts for all your assets and wealth, as mentioned before. This is very important to really list out everything you own and make sure you deal with it, dispose of it through that will. It identifies, addresses, and mitigates potential issues or disputes that may arise after your demise. So if you feel that there may be some issues surrounding a certain, let's say, piece of land or something that you own, having that in your will really, it mitigates the possibility that people assume your intention or say, no, this was meant to be for me. If it's in the will, then there's no scope for dispute. It clearly allocates your estate. Again, it ensures that your beneficiaries are able to exactly apportion what they're entitled to vis-a-vis each other as well. So there's no hard feelings. It's just will, and then we follow it. That's it. It also specifically outlines any special bequests. So if you have a cause, a charity, something that you support that is outside your family, or outside of passing on your wealth to your future generations, if it's something that you're passionate or you care for, then you can also make provisions for that in your will. So after all that information, I'm going to bring up some aspects that are not really part of the mainstream will process, but some things, just some food for thought, things that are part of the estate planning procedure, but not necessarily part of the will procedure. Just keep these things in mind if you are thinking estate planning. Social media accounts in digital world. We have, all of us, I think, now have presences on social media, more than one, platform. And, think about what you would want to do with that data, that information that you've put out there in the event of your demise. Plan for things like that. Questions of nominee versus beneficiary. So these are, nominee versus beneficiary. So it differs whether it's a life insurance policy or if it's a bank account versus if it's, shares in companies. So just be sure that when you say nominee, beneficiary, and you add someone as one, you know exactly what that entails depending on what the asset is that you're thinking about or you're talking about. Registering wills. Now, wills don't compulsorily need to be registered, but one should seriously consider doing this because it seems to be a more relied upon document by authorities, by banks, etc. They prefer registered wills. You don't have to, but if you'd ask me, I would say absolutely register your will. Probate of wills, succession certificates. Now, these are procedures that are in place in certain parts of the country for certain, again, personal laws do come in for certain religions. A probate is where a court of law declares that your will is valid and that the executor can then, carry out the wishes stated in it. So depending on where you are, where your property is in India, your will may or may not have to be probated after your death. Another suggestion here is to have a personal wealth or an asset guide that you kind of just keep on for yourself, maybe give it to your lawyer for drafting your will. It's a place where you can centralize and put in all your assets, list them out, take that time out so that you know exactly what you have, then decide who you want to distribute it to. And it just makes things so much easier when the time comes. You begin the estate planning exercise, you can start by doing this. Doesn't take that much time, as in when you think of things, just keep adding them there. Proper and timely legal support, again, just to make sure that your will is valid, that it's as watertight as possible, as enforceable as possible. It is beneficial to have someone draft it for you. There's also less of the personal that creeps in when this happens, when it's a third-party expert. So after all of that, I just want to end with this as the last thing that we need. So estate planning is important, and I would say one should begin planning as soon as possible. Do it now if you haven't already. Thank you.
Very nice. Very, very interesting. Really, this has been, again, one of the best sessions I have moderated because, with such a large 3 decades of experience, honestly, first of all, I don't have a will. And I think this, very well documented, Pranati, that these are all myths, right? And you're so correct. You all, lost friends at a very young age because of COVID or because of the after effects of the COVID or the vaccine, or even now, we are having younger deaths and, we do not realize the importance of creating a will. So we had a fantastic overview, both from the perspective of when you're buying a property, where the title is important to understand the documents required after you have created a will. And again, it's very well expressed in her presentation, where Pranati has told us that it is, there are a lot of myths around will. Even honestly, till now, even I was thinking, I don't think I need to make a will. I just have 2 properties or I have 1 property. It's not that. Whatever the properties are, you got to make a will because it is getting difficult now. And then especially for the real estate consultants, and it becomes a challenge when you want to sell that property, you don't have a will, then there's a probate problem, and there are a lot of different angles which are created, and there are a lot of issues. So before we wrap this session, I want a very quick perspective from you, Pranati. This is since from a lawyer point of view, what is the change you are now finding from a buyer's profile? So if you have, say, you have, say, 100 clients, okay, who have come to you for buying property, right? So your team has advised them on purchasing of the property. How many such clients do you have for will? So is there a lot of gap? Is there, the whole idea of this talk shows which we are doing is to build or to fill this knowledge gap. Real estate itself is a very complex process. That's what we started this discussion with. And by end of this session now, we are now realizing the importance of the legal documentation, the importance of creating a will, the importance to, it's so important right now. And as real estate values are improving and increasing, and more Indians and NRIs are also buying property, where do you see a change right now? Both can answer that. So if you had 100 clients who are buying property either for the first time or investors, are they all also getting into the estate planning, or we need to educate all our friends? There is more of such kind of education required.
Naveen, why don't you take the real estate? Because I think you should take that.
I thought this would be a good question to ask both of you to end this session. It's an eye opener, right? And I always try to get some facts and figures by end of the session so that we all realize that stakeholders, as real estate consultants, I think even the broker fraternity has an important role to play, right? To tell their clients that, it's not just the lawyer's job, right? The lawyer's job is when it comes to you. This education and this knowledge gap is to be filled by the other stakeholders.
Yes.
So if you could want to just touch that point, Naveen, do you think there's a gap? Do we think we need more of education and more of our buyers and investors to know that will is important?
Yes, I completely agree, Sangeet. It is very important. As you rightly said, most of us acquire a property and think that we have achieved and it's over. It's going to lie only as a benefit for me. It's not really so. Okay, it needs to be kept an eye upon. Planning is required, and then sometimes replanning is also required. Okay, so coming to the will, the classic example is our one of our most respected and one of the biggest stars of India, Dhirubhai Ambani, had passed away without executing a will. Okay, so the concept of will has not set in India as it should rightly do, and it is especially more required from the context that we have a very complicated system of inheritance. So if a person passes away without executing a will, then the complication in the way the inheritance happens is not necessarily very pleasant. Okay, and sometimes it goes to the wrong hands. So there are very special cases where the most unintended person receives all the benefit of somebody's property. Okay, that is thanks to our personal laws, the Hindu succession law or the Mohammedan succession law, and so on and so forth. Okay, so one can negate all of that by executing a will, and the execution of a will is a fairly simple process, except that you need some expertise in drafting and executing a good will. Okay, and as Pranati had summarized in the beginning, will is not an end all and be all. That's the only document relevant to property which can be rewritten any number of times, and the last document only prevails. He doesn't even have to mention if the dates between two wills are different, the later one prevails. He doesn't even have to cancel the previous one. So it's a very friendly document and done with a purpose, because the lawmakers have clearly identified that if one has acquired a property, he must be the master of deciding who it has to go to at any point of his time. So there are no strict rules on how it should be executed. To have it registered is a good thing, but it's not a compulsory thing. That's the only document in the real estate transfer of title array which does not require compulsory registration. So one must go ahead and as we've all concurred that there is no if there's a time to get a will executed, it is now, and the next time is when you acquire another property. Okay, and so on. Yeah.
And we have two presentations. We had this amazing dialogue starting with Naveen, where he elaborated on the title documents and the series of documents. Absolutely elaborate, right? And when we are buying, like you said, we're all excited. We bought a property and we go to Naveen and he takes care of everything. And then we just party and then we just forget about it. And then we don't create a will. And what has been shown by Pranati is a very, very simple thing, right? It doesn't take much time. What Naveen just now said, it's a very simple document. So it is, friends, very important for us that you have one property, you have 10 properties, you are Dhirubhai Ambani, or your Sangeet Kumar, or your Pranati Pandit, or your Naveen. It's very important. Whatever you are, you're 35, you're 45, or 55, please go ahead and make a will. There is absolute importance on the aspect of, and it's a very simple process like what we spoke about today. So I would really at this point thank Naveen and Prati for an amazing presentation, and all our friends who are watching us. This is not just that we have this session. You can please go ahead in the comment session and you can write to us and you can send us your information. Sapna and her team at Property Angel will be more than happy to take those questions, and then we will not let Now, this is not the end of Naveen and Pranati's commitment. They are with us. There is a commitment. The team here at MME Legal will be answering your queries. We are here to take care of all the questions after the event is over, whenever you want us. That is the entire agenda of these 3 days of sessions, of talk shows, of conversations and dialogues that has been done at the Propathon 23. So at this note, I would like to thank Naveen for the amazing presentation, and special thanks to you, Pranati, for opening our eyes and telling us how simple is creating a document, which is a will, which will take care of a lot of problems. And both your presentations had some nice cartoon. To start with, what I remember, the first cartoon of, what is an acre, and then you can't take the property with you. So both the presentations had some nice cartoons which will remain in our mind. And at this note, I would appreciate your efforts and would like to thank both of you for joining us. And we look forward. We will come back to you with any queries and questions which our delegates and attendees will be having. Thank you very much, Naveen. And Pranati, thank you very much.
Thank you so much, Sangeet.
Thank you very much, Sangeet.